So thank you, Hannah. Thank you, John. It is wonderful to be back here as I was getting off the T. I'm so used to my DC lingo now. That's getting off the T. I was thinking it's been 9 years since I was in your seat, not in this building, right over there. But so you guys are very, very, very lucky. You are in the best section. You're the best section leader. So appreciate it. And thank you all for having me. So as Hannah said, and where's my PowerPoint? Here we go. Okay. Sorry, I'm juggling a couple things here. I'm a Section 6 alum. I wanted to start by giving you just a little overview of what I'm going to talk about and a little outline so you know what's coming. I want to start by spending a few minutes telling you about what I do and what Ramchandani Colfax does, so you get a sense of what a private public interest law firm is. And then I'm going to spend the bulk of my lecture talking about RSHT, the Richmond School of Health and Technology case that we brought on behalf of 8 named plaintiffs. It was class action against the Richmond School of Health and Technology, or RSHT. So I am an attorney at Ramchandani Colfax. We're based out of Washington, D.C. I have been there just over 4 years now. And we are mainly a litigation shop, and we litigate exclusively civil rights cases. Our cases focus on housing, bringing cases mostly under the Fair Housing Act. That's a lot of what we do. But when you think of a housing case, it's not limited to sort of landlord-tenant. It's really much broader than that. We do a lot of mortgage lending cases under the Fair Housing Act. We do zoning cases. We do some straight housing discrimination cases, but it's a very broad statute. It allows for a lot of different types of claims, causes of action, very broad standing provisions. So that's the bulk of what we do. We also do a lot of lending cases. Some of those are under the Fair Housing Act, and some, like RSHT, are under the Equal Credit Opportunity Act. We do public accommodations, so that's discrimination in hotels, restaurants, places of public accommodation. Employment discrimination, we have a lot of Title VII suits, and disability discrimination. So that's kind of the overview of what the firm does. We have a nationwide practice, so we take cases anywhere. We tend to litigate almost exclusively in federal court, just because we find courts are a little bit more friendly to civil rights cases, depending on where you end up, not always friendly. And we standard set of rules as you are learning in civil procedure. So that's what we do. People often ask, how do you guys make money? So we're not all getting rich, but we all of the civil rights statutes have attorney fees shifting provisions. So as a prevailing party, if you win, you, in addition to whatever damages the plaintiff gets, so their compensatory damages, which includes emotional distress, they also are entitled to their attorney's fees. So we, as we work, we keep track of our time, and then at the end of a case, either through settlement or if we win through a trial, we'll submit a fee petition to the court and get our fees that way. So we get paid for our time, sort of after it's invested. We also have a compliance practice where we advise progressive lenders on their civil rights obligations, and so some of our revenue stream comes from that practice. I want to talk a little bit about the differences between a private public interest firm and a nonprofit or government. I think the key difference between a nonprofit is that we are not sort of obligated to any board of directors or grants. We fund ourselves. We don't have to get approval to bring a new case. So it allows us to be pretty nimble. If we see a problem, we can jump on it quickly. If need be, we can be filing the next week or as quickly as possible, depending on what the case needs. In terms of the government, again, we're not sort of we're not serving a president or an administration, and we are able to take risks that I think you wouldn't otherwise be able to take because we're not answering to anybody. And so we will, if we see a problem and we think there's a way to solve it through the court system, we can try, and we are not always successful, but we're successful a lot. And so it's a pretty big luxury to be somewhere where you can take risks. The leadership at the firm is really committed to sort of pushing the boundaries of civil rights law in this country, so that we can try and get as close to a society of equal opportunity for all. So those are the main differences. If you were going to go to Civil Rights Division in the Department of Justice. They do similar work to us. I think the main difference is we're not separated by practice area. So as an attorney at the firm, I get to litigate in all of our practice areas. So I get to do housing, I get to do lending, I get to do employment, all the things I just told you about. If you're at DOJ Civil Rights, you'll focus in. You'll either be in the housing section, the employment section, education section. So that's I think one of the other main differences. And I realize all of this sounds sort of vague and amorphous when you have not actually gotten to be a lawyer yet. So I wanted to just give you a quick snippet of a day in the life of being a civil rights lawyer. So what did I do yesterday? I think this is sort of the best way. People often tell me what they do, and I'm like, no, but what do you do? Like, what do your hours look like? So yesterday, I spent the bulk of my morning drafting and revising discovery requests in a reverse redlining mortgage discrimination case that I have in New York City. And in the outer boroughs. So I'll tell you a little bit more about the case in a few minutes. I then was we have co-counsel. We're co-counseling with a legal services organization in Brooklyn on that case. So I was on a conference call with co-counsel to discuss the strategy about our discovery requests. And then I met with one of our paralegals regarding benefits and leave policies at the firm. I brainstormed with another colleague who was working on a case that I'm not on about a motion they were filing. We spent some time talking through that. And then I had a meeting appropriately with our fellow about student lending cases and some new investigations we're looking at. And then I prepared for coming here today. So that's what I did yesterday. Oh, I also supervised the service of that discovery. So if you guys have not, you probably will not learn this in civil procedure. It's good to know. If you hand deliver a discovery request, the party has 30 days to respond to you. If you email it to them, they get 3 days for the electronic service. So, shorten the time frame. We got paralegals to go out and hand deliver the discovery request to our opposing counsel. And last week, I was at a discovery hearing in front of a magistrate judge up in New York. You guys are a slightly less intimidating audience, although not quite. And then last month, I spent a lot of time writing and drafting and revising an appellate brief in the DC Circuit for a case that we lost in summary judgment that we are going to get overturned and win on trial. So that's sort of a quick snippet of the day. It's a very, as you can tell, it's a very varied day. I don't have a typical day, but that's just kind of a snippet of the types of things that I do in my day. Okay, before I go to the next slide, I have to say, putting together a PowerPoint for John's class was very intimidating. Please reduce your expectations. They're not going to be like his PowerPoints. I also cannot take credit for all of these slides. A lot of credit goes to John Relman and Glenn Schlachtis and our paralegals, who I took some of their slides from. So I wanted to give them credit where credit is due. So okay, I'm going to keep going, but please feel free to ask any questions about my work at Relman when we get to the end. Am I talking too fast? Are you guys? I have a problem with talking too fast, but I want to get through everything too. Okay, thanks. RSHT. You're doing the white paper presentation next, right? So I'm not going to spend a lot of time sort of going over the for-profit school industry because I think you're going to get some of that, and it's a topic you all are familiar with. So I wanted to dive right into the litigation. So RSHT is a for-profit college, and I put college in quotations. It's very different than the typical four-year college that you typically think of. So it's a for-profit school in Richmond, Virginia. When we started investigating the school, there were 2 campuses. Both of those campuses were majority African American, and they had programs in a whole bunch of different fields, mostly all healthcare related. So you can see those different programs up there. The cost to attend RSHT varied between $10,000 and $28,000 for programs that were anywhere between 9 and 19 months. 86% of RSHT's revenue came from federal financial aid. So that was students getting funding through the Higher Education Act, Title IV of the Higher Education Act, and that's how they were making their money, and therefore profit. So obviously they were making a profit. The Richmond metropolitan area is about 30% African American. The RSHT student body was about 75% African American, so quite disproportionate. We brought suit on behalf of 8 named plaintiffs. It was a class action suit, so they represented a class of former students based on reverse redlining. And essentially our theory was that RSHT was providing a sham education. It was a totally inadequate education. And they were pushing students, they were pushing their marketing into and their recruitment into the minority community. So RSHT was engaged, it's reverse redlining because they were engaged in the practice of targeting a minority community for a poisonous product. And here the poisonous product was a sham education.
Sorry, you said we could interrupt. So,
yes.
I want to make sure you studied redlining? Yes. Okay, good, thank you.
And actually, the next slide. So before I get more into reverse redlining and the theory here, I wanted to give a little background on redlining. So as if you guys are already dealing with some property, you know there's and just by being citizens in the world, this country has a very long history of segregated living patterns. And part of the reason those segregated living patterns arose was because of redlining in our cities. The term redlining came from realtors, from actual red lines. Realtors and brokers would have maps where they would draw red lines. And if you were African American, you were not going to get a loan or a home within those red lines. That practice is, and part of the Fair Housing Act and the COA made that practice unlawful. It's illegal discrimination to redline. So that's the tradition of redlining cases. Reverse redlining is it's very similar theory, but the idea is you are, rather than blocking minorities from coming into a neighborhood, you are targeting minority neighborhoods for a bad product. So you're peddling poison into minority communities. So the firm has done many redlining cases, and I just wanted to show you some of from the maps from one of the cases that we did in the last few years. This was Baltimore versus Wells Fargo. We represented the city of Baltimore against Wells Fargo for reverse redlining. And what Wells Fargo was doing, so this is a map of Baltimore. You can see here, so the green is African American, the white dots are white, and you can see it's a highly segregated city. Wells Fargo was targeting their loans, their high-priced loans in minority communities. So there's a sort of economic tool called regression analysis. And what you do is you hold constant all other variables to look to see if there is a disproportionate effect on a population. And what we found is that loans were priced higher in the minority community than in similarly situated white communities. So you'd have the same demographics, same socioeconomic stats, and you'd have higher price loans in the African American community. And then in the wake of the foreclosure crisis, you had much higher rates of foreclosure because of the predatory loan terms. So what do you see? You can sort of see how this happens. So this is a map of Baltimore, so same map here, so that you can see where the race lines are. This was a map of foreclosures throughout Baltimore from 2000 to 2008. And then this next map shows you the Wells Fargo foreclosures from 2000 to 2008. So you can see they are heavily concentrated in the African American neighborhoods throughout Baltimore. So we brought suit, and DOJ ended up coming in for a nationwide settlement against Wells Fargo for their discriminatory lending practices in African American communities, and that was a great result. We got a lot of capital being put into Baltimore as a result of that settlement. So that's kind of your typical reverse redlining case. So what do we see in RSHT? So we got a call from, we have Relman, we have paralegals who come in for 2-year terms. They usually come straight out of college. They're interested in law school and in civil rights work, and they come to us for two years, and they work really hard. They're great, and they bring a lot of energy to the firm. So one of our paralegals, her boyfriend was from Richmond, and his mom was a librarian at RSHT. And she was just horrified and shocked by what she was seeing at the school and had talked to our paralegal about it. And so Carly then talked to John Relman, the founder of the firm, about what Wendy Davis, her boyfriend's mother, had told her. And John it was pretty bad, the practices of the school. And I'll give you some examples of the kinds of things that RSHT was doing in the classroom. So we went down, we talked to Wendy. Wendy put us in touch with some other former employees. We talked to a whole bunch of people. And very quickly, we were also talking to students. And what was the pattern we were seeing? RSHT was vastly, the disproportionate enrollment of African Americans in the school was striking. And so this began to look a lot like our reverse redlining cases, right? You're targeting a minority community for a poisonous product. And so that's how we started developing the case. We did hundreds of interviews. I was down in Richmond a lot, as were many other members of our team. Let me see here, what's next? Okay, so what was RSHT doing? They were, I think not first and foremost, but one of the key sort of bad practices that they were involved in was a sham education. So we heard report after report of students having no supplies. My order here is different than this. Okay, so teachers who were not qualified, so the teachers who had no background in the subject they were teaching, teachers who wouldn't show up at class, teachers who would play games like just regular crossword puzzles during class. They were learning almost nothing. The courses, they would be told upon enrolling that you're going to get certified for medical assisting or certified for, surgical for being a surgical technician, and they would be completely unprepared for those licensing exams. Most of the students would fail because they had just been taught nothing that was going to be on the exam. Lack of necessary materials, equipment, and textbooks. We'd hear reports from students who were using textbooks that were 4 or 5 years old, or they wouldn't get their textbook till the last week of class. Hearing that over and over and over again. Students were told, for example, in the medical assisting, one of the things they had to know how to do was to change a catheter, change bed sheets, and they did not have those supplies, and so they were told to pantomime changing the catheter, changing bed sheets, to learn how the motions would work, but they were given no supplies. They often resorted to making photocopies of the medical instruments that they were going to need to know how to use because they didn't have actual instruments to learn on. For some of our plaintiffs who were in the community home health program, they were told that they were going to get certified as a community home health aide. There is no such certification. So these students were enrolling for a program paying, $10,000 for a program for a certification that does not exist. Many of the instructors reported similar frustrations where they would be asking for supplies, they wouldn't be able to get them. They were given no support from the school. And then many of these healthcare fields require a certain number of externship hours. So for example, the surgery technician students, they were required to have 150 surgical procedures in order to be certified as a surgical technician. And the school would promise them, we're going to get you these externships, you're going to have the procedures, you're going to be qualified when you graduate. And they would be sent to the library for their externships, or sent to labs to sterilize instruments, getting almost none of the procedures that they needed in order to qualify as a surgical technician. So that's the sham education. It was a very hard sell to these students before they enrolled. So the school engaged in a whole bunch of practices. When students would come in, the goal was always a same-day enrollment. So they would often not see the forms they were signing, the financial aid forms. It was, they were pressing them. You need to do this now. This classes are starting tomorrow. This is the time to take advantage of this opportunity. And the students we talked to really felt like they were being pressured into signing up today, or they weren't going to be, that it wasn't going to be an option for them. They needed to sign up today. Today was the day to do it. And as you can see here, loan documents were often not shown to them. They were not explained at all. They would just rush them through the signing process, signing your name for thousands and thousands of dollars of debt. The school would make all sorts of false promises to these students about what they were going to get from an RSHT education. Promises about job placement, the types of jobs you would get, the salary you were going to make, and about the externships, as I just talked about. So, we heard many examples of actual fraud in enrollment. So things like cutting and pasting student signatures onto their financial aid forms, altering W-2s and other documents to misrepresent students' income so that they would qualify for the federal financial aid, altering evaluation forms that were completed by students so the school's audits would continue to be good, and changing students' grades from failing to passing in order to keep them enrolled and to keep the federal dollars flowing. So the two things I just described to you, sort of the sham education and then the misrepresentations to students in order to get them to enroll, both those things seem like a consumer fraud issue, right? But what makes it a civil rights issue, and why did we get involved? There are a lot of people working on student for-profit schools and student debt issues. So we got involved because this was clearly also a race discrimination case. So this is a map of Richmond. Once again, you can see a highly segregated city. As I told you, the Richmond metropolitan area is about 30% African American. And the school was 75% African American. This compares to, so the white paper on for-profit lending says that generally the numbers you were seeing in 2009, for-profit schools were about 27% African American. So you can see RSHT is just vastly disproportionate to any of those numbers. So how are they targeting this practice? They were, well, those were the numbers I just gave you. Oh, and this is important too. So, one of the things that we thought that we might get in defense is, well, the population that is eligible, the population that would want to enroll in a for-profit school is going to be disproportionately African American. And so we looked at the population of students or the Richmond population of people who were over age 25 and whose highest education degree was a high school diploma. And even that population is only 33.3% African American. So it doesn't change the numbers all that much, really not at all. So what were they doing? They were pushing their marketing to the African American community. They were leaving flyers in low-income areas and in zip codes that were African American. We had former ex-employees who were telling us that they were told to target African American neighborhoods for flyers and door-to-door recruiting. They were advertising on BET, hip-hop stations. They would advertise RSHT on shows that were sort of thought to be predominantly with African American viewership. A lot of their ads talked about how RSHT was on the bus line. And in Richmond, this is a well-known euphemism for the African American community if you're on the bus line. So that was a very clear, when you say this, a lot of people will be like, well, what does that mean? But in Richmond, it is clear to everybody what that means. It's known to be directed to the African American community in Richmond. And they would do open houses in African American neighborhoods. So a lot of recruiting in the African American community. So here's a quote from one of the former employees of RSHT. So basically what we see with reverse redlining is that it reflects a belief that the minority community is ripe for exploitation, and you tend to see it flourishes when those communities have historically been denied access to whatever is being sold, right? So they're targeting a population that does not, there were not a lot of people who were college educated. We saw that a lot of the students we talked to were single moms, and they had really seen RSHT as their chance to better themselves and better their families. But they enrolled and they got nothing except for a mountain of debt. So they come out and they're saddled with debt. They are not able to find jobs in the programs that they have enrolled in. Often they're not able to get the job they had before they enrolled at RSHT. and they're left in a much worse position than they were beforehand. I can't tell you how many people I talked to who said to me, "This was my one chance, and it's over now. So it's done. I'm not gonna get that higher education degree. I'm not gonna be able to realize my dreams because I have to pay back this debt now. I have kids." And people felt like they had really been cheated, and they had been. So, as we're hearing all these stories, what's the legal theory? We brought suit. We had five claims. We had 2 federal claims under the Equal Credit Opportunity Act and Title VI of the 1964 Civil Rights Act, and then 3 state law claims. There was a fraudulent concealment claim. So there's your tort. I know we're in torts here, so there it is. And the Virginia Consumer Protection Act and breach of contract. And I just want to touch on these really, really briefly, just to give you a sense of what these laws and claims do. So ACOA makes it unlawful for any creditor to discriminate against any applicant with respect to race, color, religion, national origin. You can read it there. So the question that I get about this often is, well, why was RSHT responsible under ACOA? And the reason for that is because the definition of a creditor, it means any person who regularly arranges for the extension, renewal, or continuation of credit. So here RSHT was submitting the financial aid applications on behalf of their students. They were arranging for their credit. RSHT was also, for the white paper students, similar to the Genesis program that Corinthian did. They also had a loan that they would give to students from RSHT. And so they were actually a direct creditor as well. Interestingly enough, so the federal rules under Title IV of the Higher Education Act for federal funds say that any school cannot have more than 90% of its revenue be from federal financial aid. So 10% has to come from other sources. And so the way RSHT made up that 10% was through their own loans that they would give to students. They would often be a $40 per month payment. If you didn't pay your $40 to RSHT so they would get their money back, you weren't allowed in class. They would pull students out of class to make them make their payments. But of course, they did not care so much about those federal tax dollars that were not going to be paid back down the road. So that's ACOA. And then Title VI of the 1964 Civil Rights Act prohibits, so any program or activity that's receiving federal funds can't discriminate. And here they are obviously receiving federal funds, millions and millions and millions of dollars of federal funds. That came before I was ready for it. But I was going to talk about the fraudulent concealment claim quickly. So fraud claims under Virginia law can be based on unfulfilled promises and related representations that induce contracting if the party who makes that false representation knew at the time he was making it they did not intend to live up to it, or that they knew that it was a false representation at the time they make it. So you can, so that's sort of prospective promises, but if if I'm promising you something, I'm saying you're going to get certified, but actually I know there's no certification for community home health, that's fraud. So we had several examples of these misrepresentations. RSHT was going to prepare students to pass their certification and licensing examinations when they knew that most of their students were failing. That it was going to be placing students in externships that they needed to be certified when they weren't going to be able to do that. That they had a certification for community home health, and then about sort of the quality of education they were going to get, and they were making those affirmative representations to students in order to induce them to enroll. So that was one of our state law claims. And here you can see, so we filed suit, and we got a whole bunch of press. But it is not to say that there were not hurdles. We brought a class action, but Supreme Court, not all that high on class actions these days. I think we had a very good. We ended up having the class certified because when we settled, you had to certify the class as part of the settlement. But it wasn't contested in the way that it would have been if we had gone through litigation. on class certification. But we had it was 2 campuses, so you weren't going to be dealing with sort of a nationwide school with different practices. It was very similar practices. It was run by one administrator. There was one woman who was the head, and she was Richmond-based. And so, we were confident that we were going to be able to get a class certified, but of course, it was something to think about going forward. It was a very resource-intensive case for a small firm. So we used a lot of paralegal hours. We used summer associates. Actually, some of our summer associates were here from HLS. That summer, they were down in Richmond interviewing a lot of students. And we staffed 4 attorneys on the case, which for us is a very large number. We tend to staff 1 to 2 attorneys on a case. It's an untested theory, so nobody has brought a reverse redlining. Nobody had brought a reverse redlining case against a for-profit school before. So we were testing out a new theory. We believe strongly in it, and I was just telling John before class. We didn't get a written opinion on any of this because we ended up settling the case before the judge ruled on any of the motions. But we are, we have other cases that we're investigating. We're always looking to bring. Other cases if we hear of other schools that are engaged in similar practices. And so I think it's at some point we're hopeful that we'll get a good written opinion. It seems like a pretty clear violation of ACOA, and we're confident in the theory, but it was something that we didn't have precedent to rely on. And then there's some practical things that came up, and sort of atmospherics, right? So one of the things you often hear is, well, like these are students who aren't going to be successful anyway, so they're not going to get jobs anyway. And I think the way we come back at that is that these were, we don't know that, but they were given no chance. It was a total sham education, right? So, and you're targeting a certain population for this sham education. And so I think that's I think being able to have these sort of objective measurements of what was going wrong in the classroom and what was going wrong in their marketing and enrollment of students was pretty important to be able to rebut that. And one of the things that came up in some of the motion to dismiss briefing is that RSHT was trying to say, well, you have no evidence that we are treating white students better than African American students. Thing is, you don't need that, right? So basically, what they were saying is, hey, we're equal opportunity. We're equal opportunity bad actors. So this is a terrible education, but we're giving the same thing to everybody. So who cares? But to prove a reverse redlining case, if you have direct evidence of marketing and recruitment in the African American community, it doesn't matter then that you are treating everybody the same once you've caught them, right? So if you catch some white students in this process, they are also victims of this discriminatory practice. And actually, some of our plaintiffs were one of our plaintiffs, named plaintiff, was white, and she was also a victim of RSHT's discriminatory practices. So what happened? We ended up settling the case. We had a $5 million settlement, which meant that 4,000 students were eligible for some money back on to reduce their debt, and all of our named plaintiffs got their debt paid back entirely. So it was a really great result. As a civil rights lawyer, those days when you get to call your plaintiffs up and say to them, "Hey, we're getting rid of your debt. We succeeded." It's a pretty good day. And on the day the judge approved the settlement, they all came to court. We were all there in federal court in Virginia, and it's in Richmond. It's one of the more powerful, I think, experiences that you can have as a lawyer. So it was a great result. And then the last thing I just wanted to touch really briefly on, and then I'll stop so we can do some Q&A, is going forward. So one of the problems, and this actually was not a problem in RSHT, but a lot of these for-profit schools have very robust arbitration clauses. And so when you enroll, you sign an arbitration clause that says, I'm not going to sue you for anything that you do wrong. And so we are working on developing a theory to be able to have a workaround, and that's under the False Claims Act, right? So the False Claims Act allows any citizen, any private party, to bring suit on behalf of the United States, and they're called a relator rather than a plaintiff. They'd be called a relator. So as a relator, if you know that there's an entity that is knowingly making or causing to be made, is knowingly, let me read you the statute, that'll be easier. Knowingly makes, uses, or causes to be made or used a false record or statement material to a false or fraudulent claim. So basically, you know somebody who's trying to defraud the government and get paid on a claim. If you as a relator have knowledge about that as a private party, you can bring suit on behalf of the federal government. The case gets filed under seal, and the United States government has 60 days in practice. That gets extended. It's often they have years to investigate the case and decide if they're going to intervene and try and recoup the government's costs. If they decide not to intervene, the relator can go forward on behalf of the government. And when entities are found liable under False Claims Act, they are exposed to treble damages. And the reason for that is to try and incentivize private companies not to defraud the federal government. And so here, all of these schools, in order to get the Title IV the Higher Education Act funding, they signed something called a Program Participation Agreement. And in that agreement, they promise that they're going to abide by their Title VI requirements. And so for schools that are engaged in these reverse redlining practices, we know that they're not. They are intentionally targeting the minority community for a poisonous product. And so that is a violation of the False Claims Act. And so that's another option for examples where you have these very robust arbitration clauses, which the Supreme Court has held are enforceable.
The question that came to mind when you were describing some of the fraudulent schemes that the school constructed, particularly the specialized loan agreement for the school to actually be a creditor itself, it strikes me that they must have had the assistance of lawyers in order to structure some of their programming. And I wondered if you came across that and if there's any kind of special liability for lawyers who participate in these types of activities.
Yeah, so they did have a general counsel, but as a lawyer to your clients, all of that is usually protected under attorney-client privilege, and so something would have to rise to the level of malpractice, I think, in order to sue the school might have claims against their lawyer, afterwards, and. But that really is something that would happen between the school and their general counsel or whoever their external counsel were, rather than something that we as the plaintiffs would focus on.
Hi.
Hi.
Thank you so much for coming. I had a quick question about why you chose to settle instead of taking it to trial, because it is clearly a victory, but were you afraid that perhaps that the court may rule against you, or that it would be kind of an all or nothing kind of situation if you didn't take the settlement? Or was it a cost thing even?
Yeah, so settlement is always it's a tricky thing for lawyers, because we bring cases that we think we can win. And if you're a trial lawyer, there's nothing more fun than going to trial. It's exhausting, but it's a lot of fun, and I think there's a lot of value to having your claims heard in court. But there are always issues, right? So we, and there's some things that I can't talk about. But when you're given a good, the vast majority of cases settle, and the vast majority of our cases settle. And when defendants are scared, and I'm not making any representations here about RSHT or their lawyers, but when defendants realize that there is a potential that they're going to be facing a very big verdict, they're more likely to settle. And so, it really ends up being a client decision. It's bird in the hand versus two in the bush. And settlement can be a very good, litigation through trial takes a lot of time. So we were really early in the case, right? We had just done some discovery on class certification, but it was going to be years before we were getting to trial, right? There was going to go through all of discovery. There was going to be dispositive motions briefings, so there would have been summary judgment, rulings from the court. I have a case right now that I'm working on in New York, one of the reverse redlining cases, and that case was filed back in 2011, and we're still in discovery. So we have a deadline now. Discovery is going to be done at the end of February, but it's good. And then there's going to be summary judgment, and the judge is going to have to rule in summary judgment. And I think we'd be lucky to go to trial in 2015. And then there's appeals. So it can take a very long time. And so I think settlement often if you get a good settlement, it makes sense, particularly if your clients are eager for it. And I don't know what order the hands came in. Okay, we'll go here and then around.
Hi, I'm wondering if all of the fraudulent sham education factors were the same, but the school's population had been 33% African American, if a suit could have been successful against them?
Yeah, so I think we probably wouldn't have brought that suit because really what we're focused on is discrimination. But you do see a lot of, all of the breach of contract, the consumer protection claims, the fraudulent concealment, those would all have still been there. What you wouldn't have had were the federal claims of ACOA and Title VI. So a lot of litigation that you see against for-profit schools is based on just those kinds of sham practices and misrepresentations.
Hi. So I know that the white paper team is going to get at some of this, but could you talk about some non-litigation solutions you see? Like, should this type of school just be banned? Should there be some kind of screening?
Yeah, so the schools are regulated, and the Obama administration really has focused in recent years on for-profit lending. So, but there is a big lobby that supports for-profit lending, and so it's hard to. Policy solutions take a long time, but the Consumer Finance Protection Board is focused on this. There were just some new legislation that came out about the gainful employment rule and sort of how schools, what kinds of metrics schools need to be meeting in order to continue to receive federal funding. The federal government has a lot of power here because these schools are making money only from the federal government and taxpayers. So, I think if they wanted to, they could really have robust enforcement. And we're starting to see it. And so I think that's certainly a good global solution.
Hey, is this on? I don't know. Thank you so much for coming today. So unfortunately, I'm very much not a stranger to schools like RHST. I'm from Virginia as well, so I have a lot of friends who've been through that process. One of my cousins is homeless and got into a school. And when we investigated the school, found out the school had no accreditation whatsoever, even though they said that they did. And what's quite overwhelming for me is that you can reach out to individuals that you know, but it's very difficult to disseminate knowledge over a wider population so people kind of know how to protect themselves or how to guard against those sort of things. And I was wondering if you think there is kind of from which side it could be more effective to attack it. Do you see a role for education, meaning that people know what to look for when it comes to those types of programs, or do you think that the litigation side could be more powerful in that respect?
So I think it's both. I think that neither alone is going to solve the problem. So when you have a successful litigation, we got a lot of press after RSHT, and we got a lot of calls from students from different schools, and we also got a lot of calls from after we filed the complaint originally, we got hundreds of calls from other RSHT students, and so then we were able to get declarations, and that's what led us to being able to file a class action, realizing this was common across many years of students. So it does need to be both, because by the time somebody gets to me, they've already been a victim of a for-profit school. So, hopefully, organizers and other groups can get to people before they're enrolling as well. And through all these policy changes, we get rid of the bad schools and we make the schools that are in existence, legitimate education. So I think so. You sort of have to have all of them. It's really useful to have big verdicts because it scares schools, right? So then they think, well, we could be liable for this, so we better get our act together.
We haven't studied arbitration clauses, but I know about them a little bit, and it just seems really problematic to me that people sign away their rights without even sometimes knowing that they are in a contract. And I was wondering if you could talk about that and whether that has been challenged.
Yeah, so you guys will definitely cover this in contracts, and there are ways to challenge contracts of adhesion, but our arbitration clauses are generally upheld. So a couple of years ago, the Supreme Court had a case AT&T Mobility, and it was Concepcion versus AT&T Mobility, and they upheld the arbitration clause in the cell phone contract. So generally, courts have been pretty quick to uphold these contracts. So there are ways to challenge them, but it's hard, and we're not in a very friendly environment in terms of the courts to do that right now.